Hi, welcome back to Legal Tech Briefs. Our guest today is Lucian Pera from Adams and Reese. He is a leading expert when it comes to alternative business structures for law firms and technology companies, and I am very much looking forward to having him on the podcast today.
Carly,
Thank you
it's
for
great
joining
to be
me.
with you.
I always have to mention that when you were at the TLTF Summit, it was a standing room only room. In fact, it was crammed in a
It
standing room only room. So that's
was a
how we
great
know.
conversation.
Yeah. That's how we know it's a hot topic, and by the fact that we keep getting inbounds on this topic and are spending a lot of our time here.
Here. It's hot. We're hot apparently. It's the 15 minutes will be up soon. The 15 minutes of fame, but still.
Enjoy it while it
Yeah,
lasts.
indeed. Actually, it's more like one of my favorite movies, Almost Famous. It's more like that than fame. So anyway,
Getting there,
yeah.
famous. One topic that we were just talking about before we jumped on that I thought might be useful to kick this off is thinking about, should you be set on one type of structure? Should you be ABS all the way? Or how do you make a decision about ABS versus MSO versus another structure? And I mention this one because it's a conversation we're having all the time. So would love to get you on the record for the expert's view.
Absolutely, on the record. I do get this question a lot, and it sometimes manifests in a call from an investor or even a law firm entrepreneur, a lawyer entrepreneur, who says, "I really want to do an ABS. Can you help me with that?" It's like, well, yes, I'm licensed in Arizona. I represent ABSs. I'm a compliance. Yes, we got you. And then we back up to the real question, which from their perspective ought to be more important, which is, what are you trying to do? What's your business plan? Tell me about the practice. Tell me about whatever it is. Because there are two big paths that investors and entrepreneurs and lawyers see out there that are available to them these days. One is the ABS path, a non-lawyer owned law firm authorized. Typically today it's really Arizona, although that's maybe changing in the near future, who knows. And then the other path is MSOs. And the ABSs have certain advantages and limitations. It's a real law firm. You get to, as a non-lawyer, really own it. Ownership has its privileges, as they used to say, and yet there are some burdens. One of which is that it has some jurisdictional limitations because the other jurisdictions other than Arizona don't like ABSs by and large and their ethics rules, and so you have some restrictions on how you do that. I've done a whole paper on this, on how to extend the reach of an ABS across Arizona boundaries, and it's certainly possible, but they're burdens. It works, by the way, for some practices much better than for others. Some applications work. All right, so there's that. The MSO side is really, it's a very flexible tool. The ABS is a thing. It's a set out in regs and it's got defined parameters. The MSO is simply an approach. It's a tool, and it can be used in lots of different ways. It can be used to just have any old non-lawyer own a law firm. It can be used for a tech company to extend its reach into providing their services in an attorney-client relationship. It can be used as a way for an accounting firm to add a suite of services that are needed for their accounting clients. So it's a kind of multi-purpose tool, but it doesn't have some of the burdens that the ABS has. So those are the things you really have to work through. And again, it begins with the business plan.
I couldn't agree more. And I think it's just important to keep reiterating that there's more than one option out there for everyone. And it is goal setting. What are you trying to achieve? And then determining what's the right structure for those goals.
Exactly.
So if I take a step back now, you helped rewrite the model rules. Now that we are long time ago, now that we are living in an AI world and AI in law, what would you rethink with those model rules? What's changed?
One thing I've learned over time, because I did a lot of rule writing for Tennessee from '95 to 2002, for the ABA, the model rules from '97 to 2002, roughly, is the difference between how you get guidance, how you develop governance for the profession. And my feeling is pretty simple. The rules are pretty darn good as far as AI is concerned already. I don't think, and the consensus of the ethics people I know is that I don't think there's any need for a change in the rules. There's a need for interpretation of them. And we now have, the good news is, and I do this when I talk about AI and ethics in seminars, the good news is there's lots of guidance now from ethics opinions and things like ethics opinions. There are several dozen, I think, jurisdictions that have put something out. And by the way, the second really piece of good news is, unlike prior experiences in my lifetime with ethics, governance, ethics rules, and technology, we haven't screwed it up yet. In the 90s, there were a couple of opinions when email was young that said, "Oh, you can't use email because anybody can get at it," and all this crazy stuff. It took a couple of years, but we sorted that out. None of the several dozen pieces of ethics authority out there for AI have really screwed up. So we've got good guidance from a lot of places. It's broadly consistent, and nobody has screwed it up. And only 2 states have even dipped their toe in the water of changing the rules. Florida has added the word AI, I think, to a number of comments to the rules. Thanks. That's nice. California is thinking about that, something like that. But it's not necessary. We're good with the guidance that's out there on ethics opinions. Now, that doesn't mean we don't have a lot of work to do on AI, because God knows we do. But the rules are not a problem at this point.
Literally, they just added the word AI.
I believe, don't hold me to this, for our Florida friends, they can call in and complain. But I believe that is all they did in Florida, is add AI, generative artificial intelligence, to 5 or 6 places in the rules. I get it. It's fine. It's part of the purpose of the rules is educational. And people go there for answers. And I'm a huge believer in getting as many of the everyday answers as you need baked into the black letter of the rules and into the comments, because lawyers know where they are and they may find them more quickly. But frankly, it's not necessary to do that. It's just not, because we didn't have. Well, anyway, it's not necessary.
Yeah, I like the email analogy. I think that is helpful to think about.
Well, again, we haven't screwed up the rules and comments on AI. God knows we lawyers have screwed up the use of AI repeatedly, and it's continuing and getting worse, not better. But maybe that's a different podcast.
Headline after headline after headline on that one.
Yes, and it honestly, it is. If there's anything that keeps me up at night these days, it's not really so much the validity of MSO models. It's how many good lawyers are not well enough trained and experienced in using AI, and who need to use it. So anyway, it's a continuing problem.
Yeah. When in reading your published work and about you, one of the words that stood out to me was you used the term madness when referring to fee sharing with non-lawyers, and what a fabulous word. Wanted to hear why the term madness.
Because it drives me crazy. I can be maybe too colorful sometimes, but it drives me crazy. I mean, and just the quick tour is that there's no way to make rational sense, whether for a lawyer or a non-lawyer, anybody, your 15-year-old or your grandma or your lawyer, out of the way over the last decades, fee sharing rules have been interpreted. So, for example, percentage leases, law firms can't do that, but they can pay MasterCard 3% of their fee, the fee they get. Figure that out. Recruiters, you can pay a recruiter on the basis of a percentage of their salary for the year, but you can't pay them on the basis of how much money they collect for you. No, that's illegal. Profit sharing bonuses for marketers. If the marketer is your employee, no, of course not, unless it's a profit sharing bonus across the whole firm. But you can't do even that for an outside consultant, right? Figure that. Court awarded fees, you can sometimes share them with some nonprofits. Why? We like nonprofits. Nonprofits are good. No matter what their cause, if their cause is to destroy the rule of law or not. I mean, nonprofits are good, and so they get a pass on some fees. So I tell people, actually, literally what I tell people sometimes is, after walking through some of the rules that are relevant, and this is about MSOs too, I say, look, you need to recognize that the fee sharing law, it's really a question of belief. It's like a theological question, because if you try to make sense out of it, you're just going to go crazy, hence madness.
Is there a reason it's persisted in your mind?
Yes, the self-interest of lawyers. Okay, maybe I overstate a little bit, but My favorite law review article, I don't know if we've talked about this before, my favorite law review article of all time, and I seriously recommend to the audience, if you haven't seen it, you should read it too. There's a law review article called The Lost History of Auto Clubs. And auto
I
clubs,
have seen it. Yes.
isn't it's remarkable. I'm hoping maybe Netflix will pick up the rights, but it's about AAA and a bunch of other auto clubs in the period from the dawn of autos, which were huge game-changing technology, teens, 20s, whatever, somewhere around there, all the way up into the 30s. And those auto clubs ran internal law firms where they employed the lawyers as employees. And if you needed a map, sure, you could get a map from them like you always did. If you got pulled over in Pocatello, Idaho, and got arrested for going, for some speed trap, they would send a lawyer. They would send a lawyer to bail you out of jail. If you got into an accident, they would give you a lawyer, no additional charge, to bring suit against the other driver or to defend a lawsuit. They did everything legal related to your ownership of autos. Well, come to find out, eventually, the bar didn't like that very much, and a bunch of bars took out after them and put them out of business, and thus created both law and case law about the unauthorized practice of law and about fee sharing. So, there's not much doubt now about the history now that's been revealed. Nora Engstrom and, oh my gosh, a fellow named Jones wrote this great article. And I don't mean to be too offensive or crass about my fellow lawyers, but I don't think there's much question that, the ban on fee sharing, in fact, today mostly serves to protect the monopoly. I just don't, that's what I've come to believe over time, more and more, and part of it is you look and see what effect it has. There are some of those effects that have changed, I think would improve access to justice. But I'm more offended, frankly, by the fact that there doesn't seem to be a policy justification for it anymore. That's what gets me. So, long answer. Anyway.
I would greatly enjoy the Netflix
Yeah.
show. I
You
think it's
never
got the
know.
period
I mean,
piece. It's got drama. I would watch that. I could see you starring.
Oh yeah, right. I think that's not unlikely. But anyway, okay.
So on this topic, you've said that KPMG, when they set up in Arizona and got approval, it sparked the imaginations for everyone. What else has come out of that now that we're some time into it?
I would go just a hair back further. When Arizona enacted its reforms in 2021, both repealing the fee sharing ban completely, and also enacting the ABS program, people's minds started to expand, and that's when we started getting calls about MSOs, of course, and ABSs, but about both. And then last year, right, 2025, in January, February, when KPMG got its ABS license, people's minds expanded another little bit. And it wasn't because, there are only so many accounting firms. It wasn't because somebody said, I got an accounting firm and I want a law firm. No, what happened was people saw that and said, KPMG, Big Four, what? They have a law firm? What? How's that work? What's that about? And then as soon as they got that part of their mind open, they realized, wait, ABS, okay, so anybody can get one. Oh, and wait, there's also this other thing, this MSO thing. What about that? And that's what happened. The downstream effects of that have been this land rush we've been experiencing. I know we were talking about before we started recording. You've been experiencing it. I've been experiencing it. So that's the effect. Now, what other effects have there been? People keep asking, well, has there been any backlash? I don't know that I want to call any of the reactions that have happened so far a backlash, because I don't think they are quite organized enough to merit that name. There are two pieces of pending legislation, one in Illinois, one in California, both of which are addressed to MSOs. One read of them is that they impose requirements on MSOs that can be, to a lot of investors, broadly consistent with how investors have to do MSOs, consistent with the ethics rules anyway. Yes, there are a few differences, but neither of them tries to outlaw MSOs. I'm not sure you could do that legitimately. And the final thought on that is that I do think some people have concluded, well, if these pass, then that provides some legitimacy for MSOs. It says you can have an MSO if you comply with all this. But at bottom, I don't think it's a backlash, in part because I see where it seems to be coming from. I don't sense any regulators saying, oh my, for the public good, for client protection, for public protection, we must stop this. We must. One reason is that, and just to finish that thought, the people who are pushing those two pieces of legislation, they are competitors. They are guardians of the moat. They are plaintiffs' lawyers, mostly. So, but the regulators have been quiet. I think it's because there are people like me out there, candidly, who are ethics lawyers, and who, when somebody comes to us, and not everybody goes to an ethics lawyer, but when somebody comes to us, we say, you can do that, but there are these 12 things you got to do to make sure you're compliant. And when you do that, you pull up Rule 5.4 in most jurisdictions and you comply with those. They supply a lot of client and public protection. And I think it's enough. So I don't think the regulators are yet giving any indication of any kind of real backlash.
There's probably some interesting key learnings from this conversation, regulation, and AI in regulation, and that everyone's brains are expanding at the same time in multiple different vectors.
The AI thing is really, it's actually, in some sense, well, anyway, it's different. I was going to say it's more interesting. I don't know that it's more interesting, but it's different because there is all this tension out in the land, way above my pay grade, about regulation of AI. And of course, that's regulation. There's discussion at the federal level, there's discussion at the state level, there's an executive order setting up for all this stuff that I don't completely understand. But it is, I tend to be on the side of less regulation rather than more, notwithstanding our difficult experience, I think, with Section 230 over the last however many years. Section 230 being the legislation in the 90s, 92, 3, 4, 5, somewhere in there, that said platforms can't be held liable for the content on them. Some people saw it as the sort of charter of freedom of the internet, and it allowed AOL at the time and a lot of others to be protected from liability. I think even though a lot of people have difficulty with some of the consequences of that, think of the Facebook trial recently, the truth is, it really did enable a complete revolution, thanks to the internet. That's, I think, what we're seeing with AI at the moment. And I think there's a lot of pushback on the regulation because people fear that we will lose the benefits of AI if we crack down too hard. But can I narrow us back to our original topic, law, for a minute?
Sorry, I took you elsewhere there.
No, it's okay. I'm glad you did. I took myself there. My hobby horse at the moment is about UPL and AI. And my view is pretty simple. I think it would be wrong for us to use, and I don't think UPL law should be used to crack down on most AI legal help. One of my pet projects, and by the way, I don't think there's a huge effort to do so, interestingly, and people are in fact turning to ChatGPT and Gemini and all these services, right, Claude, for legal help. Two developments there for people to think about. One, Colorado, very innovative, has come up with what they call a non-prosecution policy. And that policy says, it's about page and a half of the requirements. So if you meet these requirements, we're not going to, and you're delivering legal help through AI, we're not going to prosecute you for UPL. And they include things like disclosures that this is not a lawyer, there's no attorney-client relationship, there's no confidentiality. So they're reasonable. And they also, by the way, have one requirement that there's got to be some kind of lawyer blessing or quality control in the background, which is fine. And they say, if you do that, we're not coming after you for UPL. I think that's a great approach. I'd never before heard of a non-prosecution policy. So God bless.
Doesn't surprise me that's Colorado.
Traditionally, you're right, actually. And I don't know if you know this, but the lawyer regulation authorities in Colorado have a very long tradition of being really sensible. So I'm pleased to hear, and the fellow who was in charge of that, he retired a couple of years back. So I'm pleased to hear they're still being very practical. The other idea is an idea that I had that I've been selling and nobody's been buying yet, except the City Bar in New York is thinking about it, and that is an amendment to the UPL statute that would accept, make an exception for AI tools, legal help by AI, so long as in conspicuous language, those tools told people, we're not a lawyer, there's no privilege, there's no confidentiality, you should get a lawyer, and I think that's about it. But it's an exception. It's actually a statutory exception you could plug into any statute on UPL. So that's my current more than thought experiment, but less than really project yet.
I'm glad you got to spread it here.
There you go. There you go. Sign up. Call her right. Actually, Tennessee is looking at regulatory reform in a serious way. Our Supreme Court put out a request for comments on every topic under the sun as far as regulatory reform. God bless them. And we're working on responding. And I've decided personally that I'm going to put in a comment proposing those two ideas to them, even though neither one of them is one they can actually do themselves. They would have to call up the AG and say, do a non-prosecution policy, or call the legislature. I don't care. I think if they want to do full reform, then AI for legal help is necessary. It's just necessary. So anyway.
We talked a lot about law firms, tech companies so far, and how they're thinking about this space. What about investors? Not only are we talking to lots of law firms and to lots of technology companies, but we're also talking to investors of every size and every shade that are thinking about how to play in this space. What is your best advice to them? How is this different than other MSO structures in the past?
Frankly, it's mostly my world. It's mostly the legal ethics piece. For example, I could be wrong because I'm not an expert on these, but you can have some form of restrictive covenant or restrictions on competition, non-competes, whatever, in I think almost all of the other fields that have been worked over by MSO structures, and you can't in law. You have different confidentiality regimes for sure. I think a stricter one probably than most. You also, although I'm not saying HIPAA isn't as strong as the privilege, but I'm just saying that's a serious concern. Conflicts of interest are policed in a more serious way. And we have, of course, the ownership rules, the ownership and fee sharing rules. I think in most of the other areas, if not all the other areas, there is not a prohibition generally on sharing of fees in these other fields that have had MSOs used in the past. And there is in law. So that means that the two areas that, well, to back up one step, my view, and I talk to a self-selected audience because no investor calls an ethics lawyer unless they want to be in compliance, right? Okay. But that said, I think smart investors ought to have every interest, every desire to be as compliant with all the ethics and lawyering rules as the lawyers. Because after all, last thing they want is to have their lawyers get in trouble. Lawyers are working with get in trouble. So that's the attitude I get from most investors. And so for them, I have the same conversation. I'm literally today working on two sets of documents that are very, very similar. They actually come from the same law firm. And on the one hand, I'm talking to representing a law firm, looking at those documents. And on the other hand, I'm talking to the investor. And I'm telling them the same thing. That's just not a question of me being honest. It's a question that I think both have the same interest. So that's my advice to an investor. Be sure you hire your local ethics lawyer or somebody to help you get through compliance because it's damned important.
Yeah. Good advice. Looking back, what have you gotten wrong? What's something that you've gotten wrong in the past?
So many. Let's see. Do we have? I don't know. We don't have enough time here today. No. All kidding aside, one thing is exactly in this area. I know if we had talked about non-lawyer ownership, I'm trying to think how long ago, 20 or 25 years ago. Certainly at the time I was on Ethics 2000 revising the model rules around the turn of the century. My view was I was just not really interested in a reform of this type that would limit the ban on fee sharing or would limit the ban on non-lawyer ownership. It didn't, because my reaction was And I literally remember talking with some people about this, that it just doesn't matter. Law firms are not capital intensive, and they don't need outside money. And um, the truth is, I don't know if that was true at the time. I may just have been, naive and young. But in addition, I've seen, and part of this, by the way, I've seen and learned by being active in litigation funding. So, for example, it's never been a huge part of my practice, but it's been a small part of my practice since 1998. And so I worked with a funder in 1998, running up through about 2012 or 2013, and went all around the country helping get them blessed in a bunch of jurisdictions, complying with the ethics rules, the fee sharing prohibitions, all that stuff. And and gradually over time, of course, you can't be exposed to that world without understanding the role capital plays in some part of the legal market. And now, of course, well, during that period and subsequently, we've had this explosion in technology. I mean, my firm doesn't generally do litigation funding because we don't have much of a plaintiff's practice, for example, and we don't do high-end cases where that's a thing. But at the same time, we can't survive, practice, thrive without spending oodles of money on technology. And so, yeah, if I wasn't wrong then, I think I was wrong then. It's certainly not true anymore. Law firms can be, and I don't know, I'm not an economist, so I don't know how to describe, a very capital intense business versus one that needs less capital. But we're somewhere on that continuum where we need some money, and outside money is useful, really, really useful. So that's one thing I think I was wrong about. And that being the case, then frankly, that has driven my view over the last 10 years or so that we started talking about the madness of the fee sharing ban and the inconsistency about law firm ownership. Um, I have the same line of chatter about non-lawyer ownership in terms of the madness of our current system, because after all, you know, uh, insurance companies have law firms. There's several flavors. One is they can have a bunch of employee lawyers in most jurisdictions who defend insurers.
Yeah.
That's a law firm. Or they don't have to buy it. They can have sort of kind of an MSO in the sense that there's a 20 lawyer firm in, let's say, Alabama that insurance company sends all their work to, and it's 75% of their firm's revenue. Well, whose law firm is that really? So that being said, that caused me over time to rethink those prohibitions. So
I think technology has exposed the need for capital in law firms. There was always a need for marketing, and there's still always a need for marketing. There's always a need for great HR functions, and there's still a need for great. But I think technology, because of the cost of technology, the ongoing nature of it, it exposed some of the other capital needs because firms started to think about it in a real way for the first time.
And the other thing, I'll tell you the other thing along similar lines. I don't think I was really wrong about this, but I mean, I will tell you, um, one of my latest thought experiments is to think through what did a law firm look like. Um, Pick a date. I started practicing in 1985, but somewhere in the early 80s, maybe. Pick what a law firm looked like then. There's some point in like 75 to 80 where law firms were the same they had ever been for 100 years. And
Hmm.
suddenly, in the last however many years that is, from 80-ish, uh, this is not your father's law firm anymore. In terms of everything from non-equity partnership to virtual nature of law firms to outsourcing to whatever. MSO is just one kind of way to think about that. But I don't think there's any question that in 5 years, I think we'll recognize law firms, but law firms will be dramatically different in 5 years. AI is a part of that. But anybody who thinks they can continue to have the same kind of law firm they had 5 years ago, 10 years ago, I'm sorry, it's just not the case.
My father-in-law is still practicing, so this is a common discussion at the dinner table.
Yeah. Well, I mean, I would ask him that question because my thought experiment is okay, take the lawyer from the 1920s, transport them in time, pick a year. How far can you move them and still drop them into a 1975 or 85 law firm and have them quickly realize where they are and understand how things work? Because I don't know when it is, but that 20s lawyer, they would recognize a 1960s firm. They would recognize a 1970s firm. I think they'd recognize my 1985 firm. but they wouldn't recognize my current firm. They'd have a bunch of questions like, "This is really a law firm? This is how this works?" Well, I mean, seriously, I bet that's what
All
your
these
father-in-law.
Zooms, all these.
Yeah, Zoom. What is this Zoom? More importantly, we got 350 lawyers, and they're spread over, I don't even know, 18
Yeah.
offices. And so if you walked around my office, I don't know, we've got 10 lawyers or something in our office, maybe 11, something like that. But so we're small, but we're also part of a 350 lawyer law firm. What does that sound more like, a bar association than a firm? It would to
Mhm.
somebody from the 1970s. Anyway, but that's at the heart of the change we're talking about.
Last question. What are you most optimistic about? What are you most excited about the next few years ahead?
Two things. One is AI. As scared as I am, and I am scared not of the coming, apocalypse, because I for one, in the words of the newscaster on The Simpsons, I for one welcome our AI
Yes.
overlords. But that said, because I'm sure they're listening, but I do think it is fully as big a change that's happening to us as the internet was. Not computers generally, the internet. So that's a change, and we're still, God, it's scary. It's just really scary. But I think that has tremendous potential to change the lives of lawyers, but also to get legal services out to more people than ever before. The other thing is, and I don't have a name for it yet, but it's part of what's being forced on us, or it's happening because of the inflow of capital. Um, there was has been a professionalization of law firm operations and practice that people who don't like it, maybe your father-in-law, I don't know what his attitude is, who, some people see it as the death of the profession. We're not a profession anymore, we're a business. Okay, well, we're both, hello. But the extent to which the law practice is being professionalized and turned more into to have some of the benefits of being a business, that's clearly accelerating. It's like people talk
Yeah.
about government. They say they want to run government like a business. Well, yeah, okay. You can run government and have it be efficient, if that's what you mean by like a business, or be effective. Yeah, that's what I'm talking about for law firms, because law firms have been so horrible for so long about everything from HR to, I don't know. The list is, we don't have enough time.
Well, I don't feel like I've heard that yet from law firms. I agree with you that it's on its way, but you do hear it from dental practices and medical practices, and I've certainly heard it there in the past few years. So I can only imagine we will start
Yeah,
hearing it
yeah.
from lawyers.
And they'll blame us,
Yes.
you and me.
We'll
They'll
come
blame
back
us.
here.
Yeah. They go back and pull up this podcast and say, these are the criminals. These are the people who brought this to our doorstep. Anyway, but I'm fine
Or
with
they
that.
brought us this opportunity and we're so
That's
thankful.
right. That's right. Well, I'm good with that. As I say, I for one welcome our new AI and business overlords. So anyway,
Well, thank you so much for joining me today. I
absolutely.
greatly enjoyed this conversation.
Great fun. Thanks for having me.